And Dalyne and Yanez final part finished. Kuhn, Powell, Bresno, and Wynn were tried in California state court on charges of assault with a deadly weapon and excessive use of force by a police officer. The officers were acquitted of all charges, with the exception of one assault charge against Powell that resulted in a hung jury. The jury was composed of 10 Caucasians, one Hispanic, and one Asian American. The verdicts touch of widespread rioting in Los Angeles. More than 40 people were killed in the riots, more than 2,000 were injured, and nearly $1 billion in property was destroyed. Los Angeles Mayor Tom Bradley declared that there appears to be a dangerous trend of racially motivated indecence running through at least some segments of the police department. And President George H.W. Bush announced in May that the verdict had left him in a deep sense of personal frustration and anger, and that he was ordering the Justice Department to initiate a prosecution against the officer. On August 4, 1992, a federal grand jury indicted the 4 officers, charging them with violating King's constitutional rights under the color of law. Powell, Bresno, and Wynn were charged with willful use of reasonable force in arresting King. Cohn was charged with willfully permitting the officers to use unreasonable force in arresting King. Cohn was charged with willfully permitting the officers to use unreasonable force during the arrest. After a trial, the U.S. District Attorney of California, the jury convicted Cohn and Powell but acquitted Wynn and Bresno. Cohn and Powell were sentenced to 30 months in prison. This jury was composed of 9 Caucasians, 2 African Americans, and 1 Hispanic. Ken later won a 3.8 verdict from the city of Los Angeles. He used some of the money to stab a record business. The issue to consider is whether officers King and Powell may be prosecuted and acquitted in California state court and then prosecuted in federal court. This seems to violate the prohibition on double jeopardy in the 5th Amendment of the U.S. Constitution, which states that individuals will not be twice put in jeopardy of life or limb. Double jeopardy means that individuals will be prosecuted more than once for the same offense. Without this protection, the government could be subject people to a series of trials in an effort to obtain a conviction. It may surprise you to learn the judges have held that the dual severity doctrine permits the U.S. government to prosecute an individual under federal law who has been acquitted on the state level. The theories that the state and federal governments are completely different entities. The state government is primarily concerned with punishing police officers and with protecting residents against physical attack, while the federal government is concerned with safeguarding the civil liberties of all Americans. Each of these entities provide a check of the other to ensure fairness for citizens. The evidence introduced into 2 prosecutions to establish the police officer's guilt in the King case was virtually identical, and the federal prosecution likely was brought in response to political pressure. On the other hand, the federal government historically has acted to prevent unfair verdicts, such as acquitting a member of the Ku Klux Klan charged with killing civil rights workers in the 1960s. So you believe that it was unfair to subject Los Angeles police officers to expense and emotional stress of 2 trials? In my opinion, I do not believe it was. No, let me restate that again. In my opinion, I think it was fair to put them on trial for both of those trials, so that they are police officers and they know when to stop using their power and when they are passing their usage power. As the Attorney General to the United States, would you have advised President George Bush to bring federal charges against officers following their acquittal by California? I would have. I'm Dalyne, Yanez. Thank you.